Good afternoon, everybody. Welcome to another session of Law Accent's Facebook Live. I'm Oluwasegun, in fact, and today we are going to be talking about a rather interesting topic, as always, something insightful, something that you're going to learn from. So, we have a mandate of bringing law closer to the people. So, today we're going to be talking about how to handle dismissals and terminations from employment from the employee's perspective. We already started this out in this series, and I suggest that you watch the other videos too that are in this series so you can get a proper understanding, because we've come from the perspective of an employer, and today we're going to be discussing from the position of an employee. We all know that employment disputes are a thing when it comes to corporate practice, usually, because more often than not, majority of employment contracts usually come to an end on not so friendly basis. And what do I mean? Most times where an employee wants to leave an employer, the employer may not necessarily be okay with the employee leaving, and where an employee wants to leave too may not necessarily be okay. And even when the employer wants to fire an employee, the employee would most likely not want that too. So these scenarios can cause a whole lot of tension. So we are going to be talking about how to handle it from the employee's perspective. That is, if your employer should dismiss you or terminate your employment, what exactly can you do? Are you left at the mercy of your employer and all of that? There was an uprising in the number of questions that came regarding this subject because of the breakout of the pandemic. Because we saw a whole lot of scenarios where majority of corporate bodies realized that they couldn't keep up or meet up with the needs of their employees because of the breakout of the pandemic, because they were not bringing in any forms of money or bringing in any form of profits during that period. Majority of business activities were shut down, most companies were not working. So we had scenarios where people's emolument, your remuneration, your salary was slashed, some unilaterally, some mutually based on agreement, some people were laid off and all of that. So we are going to be going into the intricacies of how this thing actually plays out and where you stand as an employee. So employees usually ask questions like, okay, how do I handle this scenario? Do I just move on? Many move on if they can, but some find the scenario so peculiar, especially when they feel like it was not warranted for and they have like some form of stake or something that they want to protect. So for us to better understand this, I'll first be talking about the difference between a dismissal and a termination of employment. Most times people just use these two words interchangeably, like they are the same, but they are not. Dismissal comes more as a punitive measure. Dismissal is a punishment. Dismissal is a reaction to an action that an employee has committed. So when you do something wrong or you commit an act that amounts to some form of insubordination or let me say gross misconduct, for example, criminal acts, sexual harassment, probably in the workplace or even outside the workplace, and it comes to the attention of your employer, you can actually get dismissed. So it is a punitive measure, like I said. It is usually a punishment. But termination is an intention to actually end a contract of employment. So you can agree to terminate your contract of employment with your employer at a future date. It doesn't mean that it has to be immediately. But a dismissal works once it is instituted. Once the dismissal is put on the table, it has to take effect almost immediately. So something that would actually descend them to is that most times when you are dismissed, you are not entitled to any form of gratuities or payment or even salary for the month, even if it was on the, say you were dismissed on the 24th. But then there are dissenting opinions that suggest that a person can be paid up to that moment where it is a dismissal even. But then that's one of the things that dissents a dismissal from a termination. The termination will still leave you entitled. It's like I said, your employer can give you notice that they want to terminate your contract of employment in December. That's notice given already. So it is an intention to terminate or end the contract in the future at a future date. So like I mentioned earlier, a dismissal and a termination are not the same. The key thing to note is that a dismissal is a punitive measure. It is punishment for something that you have done, while termination is either based on agreement mutually, or your employer gives you a notice, expresses the intention of wanting to end your employment contract. So having said that, we'll be going into what actually constitutes proper termination. Basically, if your employer wants to terminate your employment, they cannot just terminate because they want to terminate. They can, but at the same time they cannot. What do I mean by they cannot? There has to be some form of procedure that has to be followed. There are some things that have to be put in place for it to constitute proper termination. So in other words, termination has to be proper, even if they are doing it for some reasons, but it has to be proper. It has to follow certain set out procedure. Sometimes your contract of employment usually contain what's supposed to constitute proper termination, but where that contract of employment does not contain that, you'll be left at the mercy of the Labour Act, or with the provisions of the Labour Act. And it provides that where somebody is an employee and has worked for you from within, or you have worked in a place for 1 to 3 months, you are entitled to 1 day's notice. And that 1 day's notice can even be given orally. If you have worked there for a period of within 3 months to 2 years, you are entitled to a week's notice before they terminate your employment. But if you have worked from between 2 years to 5 years, you are entitled to 1 month's notice. Sometimes the parties, that's the employer and you can agree that the notice period is going to be 3 months or it's going to be 6 months, depending on the sensitivity of the sector or the business or whatever it is that you are doing. But it is always still subject to what the parties agree to. So it is where there is no provision in your contract of employment that the Labour Act will now come into play. So even though a notice is needed, there is one thing that most people that have had something to do with terminated employment will usually see, or when you hear of payment in lieu of notice. So what exactly is a payment in lieu of notice? It's basically saying that, okay, so instead of me to give you notice, I just pay you off and you go. Formerly, the position was that if you want to terminate somebody's employment immediately, you have to pay the person for that month. But then, over time, the law has evolved, and now it provides that even if you pay the person for that month, it does not still mean that that notice has been given. So basically, let's say they want to terminate your employment by the end of October, or they want to terminate your employment by the end of November now, and then you are told on the 15th day of October, and then they pay you for the month of October, they still have to pay you an extra month. That's the payment in lieu of the notice, because if they were to give you a notice in that October, it was supposed to take effect November, or the employment was supposed to end November. So that gives you, there's supposed to be an additional month's payment. So that's basically what payment in lieu means. It means that instead of giving you notice, I pay you off and you go. So calculating how exactly the payment in lieu works is not so hard. It may seem like, well, they paid me something. They don't have to pay you something. You are entitled to everything that you ought to be entitled to for that month. So they pay you, and then if they plan not to give you notice, depending on the time when the payment of the salary came, they actually have to pay you for that extra month. So if they terminate your employment immediately on the 30th day of October and they pay you for October, they still have to pay you for November. It is that November's salary that's going to be payment in lieu. Because if they were to follow procedure and they gave you that termination letter on the 30th day of October, you would have of November either ways and gotten your entitlement or salary or whatever. So there's another thing that would usually come in for terminations, and this is terminations for redundancy. They are known as business purpose terminations. So if basically the law says that what this thing means is that if you want to lay off like somebody or some employees because you feel like you have excessive workforce or you have too many employees, you need to do it in a certain way. If that's what basically covers for redundancy. So if you plan to dismiss your staff or terminate the employment of your staff because of redundancy or for business purposes, like you feel like, oh, I have a company now and we have too many IT personnel, we have 7, I think we'll be fine with 5, and then you choose 2 that you want to lay off. In laying them off, it has to be based on some form of merit or credit or their skills, basically. And even while doing that, they are still entitled to salaries, allowances, and where a redundancy is used. Most times you notice that in some letters of termination, you usually see that some employers will come under the guise of they have too many employees or the workforce is too much and they feel like they want to cut off or they want to lay off some people. So you're entitled to your bonuses for that year. You are still entitled to your leave allowance for that year. Whether or not you've used it, you are still going to collect your leave allowance if it is for business purpose or termination for business purpose or, like I mentioned earlier, for redundancy. So there are some times where in your contract of employment there's usually a severance fee that is attached to it. As an employee, you are entitled to that severance fee. So aside from your salary for that month, bonuses, your leave allowance, you are still entitled to a severance fee if your contract of employment provides for it. If it provides for it. So moving away from termination, now let's quickly go into dismissal because we have to quickly wrap this up because of our time. Dismissal is, like I mentioned earlier, it's a punitive measure. It could be for insubordination, gross misconduct, committing a crime. But then, even though most employers are usually within their rights to actually lay people off or dismiss your employment for something that you supposedly did, you still have to go through some form of procedure. So where they allege that you did something, it has to be proven that you actually, they have to give you the opportunity, they have to hear you out, they have to give you fair hearing, they have to actually listen to you and decide on it. They have to constitute an impartial panel. Your employer must not be one of them. Where the employer is, there is going to be bias. Judge, jury, and executor. So the employer is not going to be there. There's going to be an impartial panel that's going to investigate that or listen to both parties, listen to what actually happened and why it is you feel like you didn't do that thing. So if that procedure is not followed, then there is a wrongful dismissal. So there are also some forms of employment that there's procedure stated or there's express procedure, and those are employment that have statutory flavor. Statutory flavor means that the government employed you. So because it is not a person that put you there, one person cannot sit down and say they want to remove you from your seat or from your position in the office if you work for the government, like in the civil service, for example. Now you find out that in most of the statutes that create this post or this position or that establish ministries of government and all of that, they would usually be guided by a code of conduct or some form of rule or procedure that specifies how exactly it is they're supposed to handle dismissal. So usually you would see that you may have to face the tribunal first and probably face another committee that will now decide on whether or not you can be dismissed. So they can't dismiss you first. They first conduct the investigation or the tribunal, whatever, before you're now dismissed. As a matter of fact, under the law, if you are dismissed without them going through the normal procedure, there is no dismissal. And you cannot even be said, it cannot be said that you have lost your employment because it is held that that can actually not happen. There is no existence of it. It is not in the record. They didn't go through normal procedure, and that means it is wrongful dismissal. So basically, it covers for workers that work for the government, and if they do not follow those procedures, it is unlawful. Some contracts of employment would usually have some procedures. Sometimes, some employers put it in there. So as an employee, you should always look out for those markers. So where that procedure is stated and it is not followed, and there is a wrongful termination, then there's a problem. So while looking out for the procedure that they use, if it is for dismissal and they allege that you did something, they have to let you know what exactly it is you did and hear you out too. Fair hearing, that's the important part. It is after they have heard, an impartial panel has heard you, they can now decide on whether or not you are going to be dismissed. So normally an employer has no obligation to actually state reasons why they are terminating your employment as far as they go through the normal procedure. But over time, the courts have frowned at that and they've recommended that the best practice actually is that employers state reasons why. But more often than not, we'll see that most employers actually don't state it because they don't want to have to go through the hassle of having to debate with you why they are laying you off or why they feel you should leave. Because once they state reasons, they have to prove it. It has to be justified that those reasons actually are there. So there are lots of procedures, like I mentioned earlier, where it's redundancy, where they want to fire mass and mass, or they feel like they want to discharge some people because it is not convenient for the business. Those set of employees are entitled to their yearly bonus, annual bonus, or monthly bonus. Bonuses that have accrued as at the moment when you were still working, your salaries, your basic salary, you're entitled to them. And another thing I would like to point out is that when an employer wants to dismiss like employees en masse, like not because of their conduct or something they did, but because of business purposes. The one I mentioned earlier was redundancy. Redundancy can be only one person. It could be just you. But where it is en masse, where there are lots of them, the employer has an obligation to actually inform the trade union or whatever workers body that represents that body of workers. So we'll take an example of the scenario that happened during the pandemic when a particular bank actually wanted to lay off a whole lot of their front-end marketing staff, and it has to be turned around. So there are procedures that have to be followed. You cannot just dismiss people en masse like that. You have to go through procedure, let trade unions know, let whatever body that represents their interest, you let them know, and ensure that all entitlements, salaries are properly taken care of. And this is to ensure that you do not just decide on your own one day and take people and push them out there back into the labor market. It's some form of protection that exists for employees. So what exactly can you do where you feel like there has been wrongful termination or dismissal, like where procedure wasn't followed, or where your employment was terminated and you were not paid any money, you were not given notice? What exactly can you do? Normally, employees can enforce their rights by going to the National Industrial Court. That is the court that has jurisdiction to actually hear matters that have to do with employment and trade disputes. But then, although an employer can terminate the contract of employment for any reason whatsoever, where that procedure is still not followed, is still in the wrong. So basically what I'm saying is that Nigeria's system is such that it doesn't support or provide for scenarios where there are provisions for unfair termination in some jurisdictions, in some countries. Like say you and somebody have like personal hassle, and then because of that you find a way to get the person out of the job. We see scenarios like that in Nigeria. But the system here is that the employer has the right to hire and fire. So the law cannot force a willing employee on an unwilling employer. So if your employer feels like you have to go, all they need to do is follow due process, and basically that is it, you leave. As long as they are still on the right path and they are not going against any legal provisions, they can decide that you have to go. But then if they are of the belief that, if you as an employer are of the belief that your employment was terminated wrongfully, there are routes that you can take, and that's by going to the court. Sometimes some contracts of employment provide that parties have to settle amicably, but then there are some things that have to be within that alternative dispute resolution clause, like where exactly it is, where it doesn't state where or the body that is going to handle that arbitration or whatever mediation, it is a wrong clause and you can expressly go to court immediately. So even at that, there's a time frame for when those things are supposed to go on for. If that doesn't happen, you can go straight to the court. So what exactly can you get from the court? The courts usually give damages. And the kind of damages that are allocated by the National Industrial Court for employment disputes, they are not general damages, that's the specific. So you can go on your salary or salaries that were owed to you during the period that your employment subsisted for. So while your employment was going on, if they owed you salaries, you can claim for it. If proper notice was not given, and payment in lieu wasn't given either, you can sue for those specific amounts. The amounts have to be specific. So you cannot come and claim general damages and just come and say you want 100 million from your employer. No, it doesn't work that way. There has to be a calculation of what they actually owe you. It has to be exact and specific. So does that now mean that that you cannot seek for general damages? Well, not necessarily. Where there are other events like of unfair labor practices or some form of harassment or other things like that, you can actually put in for general damages for those things. So aside from that, you can also get specific performance or reinstatement. But this would usually apply to those forms of employment that I talked about earlier, employment that have statutory flavor, if the government employs you. So basically, you can seek for reinstatement. Because the law, like I mentioned earlier, the law is of the view that, or the courts are of the view that, since procedure was not followed to dismiss this person, there was never any dismissal in the first place. So you get back to work. But it doesn't work like that for the private sector. Because, like I mentioned earlier, you cannot force a willing employee on an unwilling employer. So your employer can say, I'm done with you and that's it, we're done. They cannot now say they want to reinstate you or take you back to that office. In fact, I'm not sure anybody would want to go through the kind of whatever form of harassment or pressure that they'll put you through by being reinstated, or anybody would want to go back that way. Not unless there's some form of pecuniary interest or other interest that they may need to protect by being in the business. So basically that's just it for how you can handle those disputes. You can always send in questions that you have in the comment section so that we can treat them and talk about them more elaborately, or where you feel like there are any issues that may have come up. So it may seem on the face of it that the Nigerian system basically protects the employer because they can hire and fire, but then it actually does protect the employee too. It protects you too, because they cannot just send you away without going through procedure. Basically just provides that it is okay that we know probably it's your company, you can hire and fire who you like, but you have to follow this procedure, and you have to follow it to the latter. So where 1 month's notice is needed, you cannot give 1 week's notice. Where 2 months' notice is needed, you can't give a month's notice. Or where in the contract, parties agree to 3 months' notice, and then you feel like, no, I want to give this person 2 weeks. No, it doesn't work that way. So they have to follow whatever it is that is in the employment contract, or what is contained in the Labour Act, to the latter. So, like I mentioned earlier, the issue of unfair dismissal is still coming up. Hopefully, at some point, it would employ more. Like in the UK now, they recognize unfair dismissal. So the motive of termination is actually looked into. So for events where you want to throw somebody under the bus for some reason, or because of some employment or workplace conflict, you want to dismiss a person, the law actually protects better in those jurisdictions where unfair dismissal is recognized. So that would be pretty much it. Let me do an overview of everything that we've talked about so far. There is a difference between dismissal and termination. Dismissal is a punitive measure. Termination is an intention to actually end your contract of employment. It's not abrupt. So it's supposed to end at a future date. So for termination to be proper, there has to be notice given or payment in lieu of notice. For dismissal, the procedure has to be followed where it is that's where the employment has statutory flavor. That's for government employees. When you are a government employee, they have to follow procedure, go to tribunals and all of that before they can actually dismiss you, or before your dismissal can be held to be legal. Where it is in the private sector, where your employment does not have statutory flavor, you need to first be heard. They need to hear you out, whatever it is they allege you did, whether it is fraud or whatever. And it must be an impartial panel, which your employer must not be part of. Where the employer is part of it, that panel is flawed because there's going to be bias. So where an employer wants to dismiss employees en masse, they have to first let the trade unions or representative bodies know that they plan to do that, and for whatever reason, and they need to ensure that they properly negotiated entitlement and staff are okay with it. Specific performance from the courts where your employer seems like they want to terminate you for business purposes. That's for redundancy. They feel like they have too much staff and they want to terminate an employee. You are entitled to your salary, your yearly annual leave bonus, and other compensation or bonuses that were already due as at the time or before they terminated or they plan to terminate or dismiss your employment. Aside from that, government employees can also get reinstatement, specific performance, for them to be put back in their duty post. Because if the procedure to remove a government employee is flawed, it is flawed. It means that that thing didn't happen at all. And that basically, the person has always been there. Salaries that were supposed to have been paid will still be paid because it wasn't gone. So if it was for 3 months that he had to be away from what you will pay, they will usually pay back for that 3 months. And basically that's pretty much it. Employees can enforce their right at the National Industrial Court. That's the court that has special jurisdiction to hear employment disputes. In the event that you feel like your employment was wrongfully dismissed, always try to seek advice from counsel. Your lawyers can always put you through on your rights and whatever it is that you are entitled to under any employment contract or relationship, as a matter of fact. And it's better that way because we will find out that most times, most employers actually use very, very tacky means to dismiss or terminate the employment of their employees. And like I mentioned earlier, you should try to watch videos in the other series too, to actually give you more insight into the topic, to see how the employers think and from what perspective they come, so that it's easier for you as an employee to prepare yourself or to arm yourself ready whenever it is an employment dispute may arise. So that will be it for today's session of our Facebook Live. We look forward to giving you more insightful topics in the nearest possible future. So have a wonderful week ahead of you. Thank you for having me.